rate payable to the employees of the central government. Your lordships have that.
Yes.
Correct? Then, my lords, with your permission, I'm skipping the some part of that discussion. Please go over to page 476.
Yes.
And about 10th line from the top, you will find there is 10th line, there is no mandate.
There is no mandate.
Yeah, so I'll just emphasize that. There is no mandate either in the statutory rules framed by the state government or in the administrative directions issued by the state government as to how dearness allowance will be released by the state government for its employees from time to time, whereas the central government has specifically accepted the recommendations of the Sixth Pay Commission for release of DA to its employees twice a year, as on 1st January and 1st July, payable with the salary of March and September respectively for administrative convenience, with inflation neutralization being maintained at 100% at all levels. However, what is explicit from Rule 31E, these are our rules, 31E of, okay, it should be 31C of the ROPA Rules 2009, is that the state government has adopted the index with a base year of 1982 as the basis for determination of revised pay structure in terms of the 2009 rules by following an index as on 1st January 2006. It's also pertinent to point out what is implicit in Rule 31C, read with Rule 7 of the ROPA Rules 2009, along with paragraph 10 of the Memorandum of 23rd February 2009 and Memorandum of 23rd February 2009, is that the state government has followed the pattern of the central government in payment of DA to its employees at the same rate, but from different date, at least till 2010. Now let's go to the table, which is part of the impugned order on page 478. Page 478. Your lordship has a table there.
Yes.
Correct. Now just see, I'll just explain, I mean, at least my understanding of this table. So I'll place the table, see the heading of the left-hand first column. GO number of Finance Department, Government of West Bengal. All right. So this is how they've tabulated. Then the rate of dearness allowance released by the state government. Okay. So the rate is 2%, 6%, 9%, etc. We'll come to that. Date of effect given by the state government. So the starting point is indicated 1st April 2008, 1st June 2008. Then rate of dearness allowance percentage released by the central government. Your lordship has that. And here you will find that at least insofar as the tribunal sets out, all the way up to 23rd November 2010, you will find that the rates are generally the same.
Same model.
Yeah. However, the start point for the central government is the extreme right-hand column. So just have a look at that. Date of effect given by the central government. So do you have, for example, 1st July 2006 over there? Your lordship has that. So just see as far as West Bengal government is concerned, it was 1st April 2008. Right, same rate, but there's a slight slack. I mean, I'm just mentioning it. This is just an analysis by the tribunal itself. Then the tribunal after 2012 doesn't set out as to what the central government rates are. It doesn't, because it mentions it on that earlier page where it says that there was a consistency. But what I want to point out on the right-hand column is please see the steady increase, because eventually our submission is going to be A, there is no fundamental right. B, there is no legal or statutory right. C, it's a matter of discretion on the part of the state, which of course, like all discretion, has to be exercised in a reasonable manner under our system of governance on the basis of relevant factors. One of the relevant factors is going to be fiscal availability of funds, priorities, because of the whole matrix of circumstances which have to be looked into. But the first thing which will strike you when you see the left-hand column is that it's not as if the state government is in repose. As far as DA is concerned, even after 35, it goes up to 45, 52, 58, 65, 75, 85, 100, 125, etc. And this has been paid. Please note that. This is in terms of our rules. This is in terms of exercise of discretion. So it's not a case where DA is not being paid. It is being paid. We'll give you those figures, etc. It is being calibrated upwards. But having regard to our abilities and our decision-making broadly. And this, in our respectful submission, this whole claim of parity will find when I go to the next few paragraphs, has been expressly rejected by the tribunal. And after expressly rejecting it, or it is, I should qualify that. On my reading, they have expressly rejected it. But even after expressly rejecting it, they have brought it back in a sort of by a side door, which I don't believe is sustainable at all, which is why we went to the High Court. And of course, the High Court, as you know, has sustained it. So this table is of great value, particularly because it shows that there has been a periodic increase of DA even by the state government. And this we believe, of course, if someone comes forward to the tribunal and says that, look, this is what has been notified, but it is being denied to me, then I would respectfully submit that person has a right and the government has a corresponding duty to pay this amount. But that is the extent and scope of rights, and that's the extent to which the tribunal can go. It cannot and ought not to have done as it has over here, which is to bring in a backdoor method of parity, which is, according to us at least, not quite right. Now, yes, please.
1 minute first. I don't want to interfere in this. Just kindly come to the 7th schedule of the Constitution. I'm sorry. Kindly come to the 7th schedule. And kindly come to entry 41 of list 2.
State Public Services,
Yes.
State Public Service Commission.
State public services, because it relates to the public service of employees of the state. And therefore, each state has a different method. There are 13 states which don't follow the central government method.
I don't think so. We have any doubt about this proposition.
Therefore, the central government will never apply to us because that's our domain, under state public service.
Subject to what they say, and subject to correction, I don't think so. We have any doubt about it.
If you don't pull it, then the order says that you have to. I'm just pointing out there's a constitutional issue. That's all. I'm sorry.
No. Yeah.
Just one.
Yes. So your lordships have now seen the table and the progressive increase over a period of time.
Yes.
That's at page 478. Now please go directly, still part of the order which was challenged before the High Court, 484 please, 484.
Yes.
Now Manoj, I'm going to just read from here till let me place para 33 please. We have already observed that there is no mandate either under the statutory rules, which is ROPA. Well, ROPA is short for Revision of Pay and Allowance Rules. So ROPA 2009 or in the administrative directions issued by the state government in the form of memorandum of 23rd February 2009 and the second memorandum of 23rd February 2009, and that the DA will be paid to the employees of the state government at a rate from the date as paid by the central government to its employees. So I want to emphasize this. At least my reading of this is that they observe that there is no mandate. No mandate. At least that's how we read it. Now let's see the next sentence. In the absence of any mandate under the statutory rules or the administrative directions, we are unable to hold that the state government employees are entitled to get DA at the rate payable to its employees by the central government. So I think this is also fairly clear, my lords, at least. But what we will show you is that despite this clarity of thought here, it becomes completely woolly-headed when we go to the operative directions. But we'll come to that. However, from the discussion made by us herein above, we can hold without hesitation that the state government employees are entitled to get DA on the basic pay at the rates to be calculated on the basis of AICPI number published from time to time by taking base year 1982. Now, where is this from? May I continue after?
5 minutes,
Yes.
if you don't mind.
No, no, no.
Yes, please.
So, Manoj, may I take you, request you to move to
Where
page
is this bill? Okay.
484.
We just only wanted to remind him, tell him that he has to ensure compliance of our interim order. Only he can get it done.
Yeah, we can get.
Just tell him. Yeah, please.
Sorry, I was on page 484, paragraph 33.
Yes.
And Manoj, I read the first two sentences of that paragraph. I'm able to hold that the state government employees are entitled to get DA at a rate payable to employees by the central government. So that's clearly, Manoj, I would understand, in our favor. However, from the discussion made by us here and above, we can hold without hesitation that the state government employees are entitled to get DA on the basic pay at the rate to be calculated on the basis of to evolve norms and principles for payment of DA to its employees by calculating the same on the basis of AICPI on the basic pay fixed set up by the government of West Bengal. The state government is also due to AICPI number before implementation of the report. Start with the word however. However, from the discussion made by us here and above, we can hold without hesitation that the state should, after however, to say that it's the bounden duty of the state government to evolve norms and principles. Please see this. To evolve norms and principles for payment of DA to its employees by calculating the same, and then they make a suggestion as to how DA is to be calculated. Now, this is entirely outside the province of the tribunal, completely outside. This is entirely within the state government's province as to decide how to calculate DA, how to the rules of the memorandum. Someone has to challenge that. Challenge it squarely, you have to come up with something new. But when you have an extant rule, which is not challenged and which is not struck down, when you have an extant set of government memoranda from time to time, revising it, and you saw those rates going up, you have it, there is an application of mine. None of those are struck down through this backdoor method, whatever it means, by saying you must evolve some norms and you must evolve some principles. And you must thereafter, if there are arrears on the basis of those evolved norms and principles, pay the arrears as well. But we give you some flexibility as to how those arrears are to be paid, whether in cash. So yes,
please.
Para 37, page 488. This is the concluding portion. While remitting the case back to the tribunal, the division bench, this was the earlier round, DA on the basic pay in terms of the ROPA rules 2009. That the state government employees are entitled to get DA on the basic pay fixed in terms of the ROPA rules 2009 at a rate to be calculated on the basis of AICPI number 1982 equals 100, published from time to time till the rate, till the date of giving effect to the recommendation of the 6th Pay Commission set up by the government of West Bengal. The state government employees are also entitled to get arrears of DA on the basic pay to mitigate the loss of value of basic salary due to inflation after calculation of the rate of DA on the basis of the AICPI number 1982 equals 100 within a period of 1 year or before giving effect to the recommendation of the 6th Pay Commission, whichever is earlier. The office orders memorandums under which DA was paid to the state government employees working in so-and-so, this is in New Delhi and in Chennai, at the rate payable to the employees of the central government are struck down as arbitrary, unreasonable and violative of Article 14 of the Constitution of India. This order will not stand in the way of giving any incentive to the state government employees working in New Delhi and Chennai by way of special allowance or any other allowances to compensate. The function of pleadings is only to state the material facts, and it is for the court or tribunal to determine the legal result of those facts and to mold the relief in accordance with that result as decided by the federal court in Messrs. Mulji Jetha versus Khandesh Spinning, reported in AR 1950 Federal Court 83. Accordingly, we would like to give the following directions on the basis of the findings made by us. The respondent number 1, Chief Secretary to the Government of West Bengal, is directed to evolve norms and principles within a period of 3 months from the date of the order for release of DA on the basic pay of the state government employees fixed in terms of the ROPA Rules 2009 by taking into consideration inflation on the basis of AICPI number 1982 equals 100, so that DA can be paid to the state government employees at least twice in a year till the date of giving effect to the recommendation of the 6th Pay Commission by the Government of West Bengal for its employees. The respondent number 1 is directed to implement the norms, principles evolved as per direction of the tribunal within a period on the basic pay to the state government employees by taking into account level of inflation on the basis of the AICPI number 1982 equals 100 by following norms and principles evolved as per the directions of the tribunal within a period of 1 year from the date of the order before giving effect to the recommendation of the 6th Pay Commission set up by the Government of West Bengal, whichever is earlier. The respondent number 1 is at liberty to decide the mode and manner of payment of arrears of DA to the state government employees within the period of time fixed by us. The respondent number 1 is also directed not to give effect to any effect to the office orders and memorandums issued for payment of DA to the state government employees posted in New Delhi and Chennai at a rate payable to the employees of the central government by the respondent number 1 will not make any recovery for excess payment of salary to those state government employees. The respondent number 1 is at liberty to give incentive to the state government employees working in New Delhi and Chennai by payment of special allowance or any other allowances the state government may deem fit and proper. With the above directions, the original application stands disposed of. The urgent. Now, just please note, since your Lordship has this, if you can just go to the 4th last line on page 489. Beginning, the respondent number 1 is also directed not to give effect. Your Lordship has that?
Yes, sir.
Right. So that portion till the end of paragraph 38. End of paragraph 38. We are not challenging. We have accepted it. Right, wrong, good, bad. As far as those Delhi memorandums and Chennai memorandums are concerned. So that need not trouble this court. What we are really concerned about is the operative directions which your Lordship will find beginning with about 7th line in para 38. The respondent number 1, Chief Secretary of the Government of West Bengal, is directed to evolve. Your Lordship has that. From that until ending with the words employees within a period of time fixed by us. This is really the problem area as far as we are concerned. Now let me just make an effort to try and understand what the directions are. The directions, according to us, first and foremost, they do not, and this is very important, they do not upset the scheme under 2009 ROPA rules. That's the first point. They don't say this is bad, this is to be, nothing. So the ROPA rules have full force and continue to have full force. Second, on our understanding, they do not disturb any of the memorandums issued pursuant to these ROPA rules either. I have told your Lordship, as far as Delhi and Chennai is concerned, those memorandums struck down, that doesn't trouble me. But as far as that earlier portion is concerned, neither are the rules struck down, nor are the memoranda even touched. However, they introduce 2-3 notions. The first notion which they introduce is, which your Lordship will find, an obligation to evolve norms and principles. Now, what are these norms and principles? I already have rules. I already have government more. So they introduce this notion is directed to evolve norms and principles. Then they seem to suggest, going through the rest of the thing, that that base figure which is provided in ROPA is also required to be shifted under these new norms, etc. And payments are then to be made twice a year until the 6th Pay Commission, which is lies in the future, comes into force or whatever's earlier. So in short, this is an exercise direct, without finding any fault with the existing regulations, directing legislation to take place because they want a new law for the purposes of bringing in parity. That's the long and short of it. Because you saw that they trace in that table, they hold that there can't be parity. But then through the back door, they introduce this direction and obligation to revise without finding any infirmity. So the obligation is not a public duty to pay under some rule which we have been deficient in doing. That's one thing. That look, you have this rule, you promised this DA, but you are failing in your public duty by not following up with your own norms and rules. That's one thing. No, that's not the direction. The direction is revise. Come up with something new and pursuant to that something new which they want to have in parity with the central government, they bring back exactly the requirement of the central government rule. So that is what they really agreed by. Now, before I take your lordships to the rules, can I just state one or two things? First is we are concerned with the period 1st April 2008
1st April,
till 31st December 2019.
beg your pardon,
1/4/2008 to 31/12/2019, which is the period covered by the West Bengal 5th Pay Commission and the ROPA rules of 2009. Now please go to volume 1.
I'm sorry, it's the 6th week of state.
So my understanding is, my learned friend said 6th, my understanding is 5th Pay Commission, and 6th Pay Commission is the outer leg, which is sometime in the future. So until that point of time, you please follow this regime. That's my understanding, but they may be correct. Now just have a look at page 124 of volume 1.
yes,
Do your lordships have annexed your
yes,
Sorry. Yes. So, my lords, your lordships have page 124 of first volume.
yes,
So this you will find is title on page 124. West Bengal Services, ROPA, Revision of Pay and Allowance Rules 2009. Your Lordship have that?
Yes.
Now, before I place those rules, may I just invite attention to Article 309 of the Constitution, which is the source of power as far as these rules are concerned.
ROPA is revision of pay and allowances rule.
Yeah. Revision of Pay and Allowance, ROPA. Your Lordship, sorry, Article 309, I'll just place it.
Please.
Recruitment and conditions of service of persons serving the union or a state. I'm sorry, Constitution.
Yes, yes.
Just, could you just?
No.
Yes.
So, recruitment of, and conditions of service of persons serving the union or a state. Subject to the provisions of this Constitution, acts of the appropriate legislature may regulate the recruitment and conditions of service of persons appointed. No public services and posts in connection with the affairs of the union or of any state, provided that it shall be competent for the President or such person as he may direct in the case of services and posts in connection with the affairs of the union, and for the governor of a state or such person as he may direct in the case of services or posts in connection with the affairs of the state, to make rules regulating the recruitment and conditions of service of persons appointed to such services and posts until provision in this behalf is made by or under any act of the appropriate legislature under this article, and any rules so made shall have effect subject to the provisions of any such act. So this is our source of power. Now, if we may just place a few of those rules. If your Lordship goes to page 126,
Yes.
Article 309 of the Constitution, the Governor is pleased hereby to make the following rules. These rules may be called the West Bengal Services Revision of Pay and Allowance Rules 2009. They shall be deemed to have come into force on the first day of January 2006. Save as otherwise provided by or under these rules, the rules shall apply to persons appointed to civil services and posts under the rule-making control of the Government of West Bengal, except members of the All India Services, the West Bengal Judicial Service, and the members of the service to whom the University Grants Commission and the All India Council of Technical Education scales of pay apply. And then unless specifically extended under express order of the government, these rules shall not apply to so-and-so. Now, if your Lordship is pleased to go to Rule 3, definitions. In these rules, unless the context otherwise requires, your Lordship has that. Now, please go to 3C. Now, below 3C, your Lordship will find that there is a slight typing error because immediately below that is Roman 2. So, may I just request you to change it to 1, 2, and 3 instead of 2, 3, and 4.
Okay.
Now, existing emoluments mean the aggregate of 1, existing basic pay, 2, dearness pay appropriate to the basic pay, and 3, dearness allowance appropriate to the basic pay plus dearness allowance pay at index average 536 with 1982 equals 100. Now, this is what our rules provide. The rule does not, this is the manner in which it is framed. I will just take you to one or two other rules. But there is no concept. So there is a scale. It's specified the exact manner in which this particular dearness allowance is to be computed. It has to be appropriate to the basic pay. and appropriate to the basic pay plus DNS pay at an index average 536 of 1982 equals 100. Now, we follow this strictly and down to the T. The tribunal, as your lordship has now seen, requests us to revise, revisit, come up with something new. The rules are clear. There's no fault found with these rules at all. Where is the question? As and when the government considers it appropriate to amend these particular rules, they have a constitutional sanction which I placed before the court. If there's something wrong with these rules, it has to be struck down. But it cannot and ought not to be where you have a direction, which your lordship will recall. I'll use the exact phraseology. The respondent number 1, Chief Secretary, is directed to evolve norms and principles within a period of 3 years, 3 months from the date of this order for release of DA on the basic pay of state government employees fixed in terms of ROPA by taking into consideration inflation on the basis of the AICPI number, place 489. Yeah.
What is your colleague's name? What is her,
Your lordship has page, just go to page 488, volume 2.
what is her name?
Mahima.
Very vigilant, thank you. Yes,
But just go back for a moment. We keep this, we stick with the rule, but just go to page 488 for a moment.
yes, we have it.
See the observation in para 37. The upshot of our observations is, 5th line. The upshot of our observation is that the state government employees are entitled to get DA on the basic pay fixed in terms of ROPA rules 2009. Now this is the flourish. At a rate to be calculated on the basis of the AICPI number published from time to time till the date of giving effect to the 6th pay commission set up by the government of West India. So this is the problem, published from time to time till the date of giving effect to the recommendation. Where do they get this from? Published from time to time. So there's a continuous sliding scale according to an obligation to keep amending the base. We are following the rules strictly. We are required to follow the rules strictly. But there is no question . Fix it back to weeks. Those are the dates which I indicated to the court.
2008 to 2019.
Yes, 1st April 2008 to 31st December 2019.
First April 2000.
If not AICPI,
Yeah.
what is the basis of your calculation?
Sorry,
What is the basis of your calculation? If not AICPI,
it's exactly this,
what is,
exactly.
tell us what is your basis of calculation of DA
Yes,
from time to time?
yeah, it is, Manoj, as we take the base figure, if your lordship sees C, 3C, 3, your lordship has 3C3. You have corrected 3C3, Manoj, at page 127.
127.
ROPA rules, Manoj.
Yes.
We have to follow our rules.
Yes. No, 3C3,
Yes, that's the base figure which is indexed and fixed.
it only defines the Dearness Allowance and Dearness average 536.
Correct. I follow the statutory base fixed under the rules, and thereafter I have memorandums, government orders and memorandums issued from time to time, which increase the percentage on this base. So there is a concept of the existing emoluments, and then there is a concept of Dearness Allowance, which is indexed on the basis of the existing. Now see the existing emoluments, very, very clear, means the aggregate of existing basic pay, Dearness pay appropriate to the basic pay, and Dearness Allowance appropriate to the basic pay, plus Dearness pay at index average 536. 1982 equals 100.
Where is this geo?
Yes, so there is a series of geos which we will come to once I place the
Yes.
rules. But just to give you an example.
When it was released,
So from,
at 2% for the first time,
yes, so,
after ROPA 2009,
yeah,
give us that geo.
yes, so many of them are on
That
record,
geo-
so I'll just answer that.
1692 of 23rd February 2009. Give us that geo. The first
Okay, so
geo.
you just go to page 162,
162.
same paper book. I believe this is what your lordship is asking for.
Yeah, so that we understand your basis of
Yeah.
release of GA and the AICPI basis.
Yeah, I'll just place. I think what the court is putting is very pertinent. Your lordship has 162.
Yes.
So just note this. This is one of the.
The first one, 23rd
Memorandum.
February 2009.
Sorry, yes, 23rd February 2009. May I place this before you? And
Yes.
then I'll come back to the rules.
Yes.
I'll go back to the rules.
Yes.
So just see this subject. Clarificatory memorandum of the West Bengal Services Revision of Pay and Allowance Rules 2009 and on allied matters dealt with by the 5th Pay Commission. In Finance Resolution dated 28 August 2008, the government constituted a pay commission, and then the remit of the pay commission is indicated. Para 2 deals with scales of pay. Paragraph 3 deals with fixation of pay in the revised pay structure. Now there is a specific paragraph, which is paragraph 10, relating to Dearness Allowance. And may I take you there? It's at page 166.
Yes.
Your lordships have 166.
Yes.
So I'll just place this. Consequent upon revision of pay of government employees in accordance with the West Bengal Services Revision of Pay and Allowance Rules 2009, the Dearness Allowance to which government employees is entitled from time to time since the first day of January 2006 needs to be related to pay in revised pay structure. Necessary government order in this regard has been issued with Finance Department memo dated 23rd February 2009. And that your lordship will find at page 168. Could I just take you 2 pages further? Last para 3, reference to Rule 12 of the West Bengal Services Rules 2009 that no arrears of pay and allowance to which any government employee may be entitled in respect of the period so and so to so and so shall be paid to the government employee. The Dearness Allowance admissible to a government employee needs to be related to his pay in the revised pay structure with effect from 1st April 2008 only. Accordingly, the Governor is pleased to decide that the dearness allowance payable to government employees with effect from 1st April 2008 shall be as follows. So from 1st April to 31st May 2008, rate of dearness allowance per month on basic pay is 2%. Then for the next period, June to October, 6%. 1st November 2008 to 28th February 2009, 9%. 1st March to 31st March 2009, 12%. And 1st April 2009 onwards, 16%. On the basic pay, rate of dearness allowance per month on basic pay. Then overleave, the payment of dearness allowance under this order from the dates indicated above shall be made after, sorry.
They were getting any dearness pay at that time.
Earlier they were getting, but that's under a different set of rules, earlier rules.
No. Under the ROPA,
Our rules come in 2009.
3C4.
Actually it's 3C3. Because I requested you to just make that correction.
Okay, 3 or 4.
Anyway,
Yeah, that's right.
Later, 3C3.
Yeah,
Dearness allowance appropriate to the basic pay plus dearness pay.
yeah,
It is plus dearness pay.
yeah,
Basic pay plus dearness pay
yeah.
at index average.
For 536.
So in this para 3 of page 168, dearness pay is not mentioned. Only basic pay is mentioned. What is this difference?
Yeah. So Manoj, the earliest dearness pay gets merged with the basic pay. For the starting point.
At the time of revision, it merges.
Yes. So that's why the concept is very clear.
Yes.
Dearness allowance appropriate to the basic pay plus dearness pay at the index average of 536.
No.
So that merges for the earlier period. Sorry.
Whenever revision takes place, the dearness allowance or dearness pay merges
Yeah,
with the basic pay.
that's right.
Then what is the need of mentioning in dearness allowance 3C3 appropriate to the basic pay plus dearness pay? If it is already merged,
No, it will just see, it says existing emoluments means the aggregate of existing basic pay. Your Lordship will see that.
yes.
Then dearness pay appropriate to the basic pay. Correct?
Yes.
And the third element would be dearness allowance appropriate to the basic pay plus dearness pay at the index average of 536.
It doesn't define the dearness allowance separately.
No, it doesn't seem to. You're right.
Dearness allowance is not defined, that means.
No. It's a percentage which is notified from time to time
Yes.
and which, in terms of which we pay.
So this formula of 536 bracket 1982
Yeah,
equal to
1982.
100
Yes.
is a formula for existing emoluments,
Yes.
not for dearness allowance. Not for
Yes.
dearness allowance. It is for existing emoluments.
Yes, it's for existing.
Yes, but
It is
not,
for existing.
not exclusively for dearness allowance,
Yeah.
but it is for existing emoluments.
Yes, that's,
Dearness allowance is a part of emoluments
yeah. I would agree with that.
and not independent.
Yeah.
Yes.
It's an element.
Yes, we are trying to
Part of the
understand.
element. Yeah.
Hmm.
So this is the notion of large existing emoluments which is to be taken.
Hmm.
On this existing emoluments, the government may, in its discretion, in terms of paragraph 10, please just see.
Hmm.
Paragraph 10 of
At page 166, which is what I had just placed before you. 162 at 166. This is the first memorandum of 23rd February 2009. Your Lordship has that? Correct? So it describes itself as a clarificatory memorandum on the West Bengal services, the 2009 rules, and on allied matters dealt with by the 5th Pay Commission. Correct? It deals with a large number of issues, and we are concerned primarily with paragraph 10 at page 166.
About this.
Your Lordship has that?
Yes, please.
Consequent upon revision of pay of government employees in accordance with the 2009 rules, the dearness allowance to which a government employee is entitled from time to time since first day of January 2006 needs to be related to pay in the revised pay structure, and a necessary government order in this regard has been issued with the Finance Department memo of 23rd February 2009. So this is moving forward. This is what the DA will be. And the DA will be as prescribed at page 168. The period is indicated and the rate of the applicable rate of dearness allowance per month on basic pay is also indicated at page 168. May I just complete this this document at
Yes,
page
please.
168?
Yes.
So please go over to 169. Your Lordships have seen the rates. The payment of dearness allowance under the order from the dates under this order from the dates indicated above shall be made after adjusting the installments of the dearness allowance already sanctioned and paid to the state government employees with effect from 1st April 2008, 1st June 2008, so and so, with a order dated so and so, respectively. The term basic pay for the purposes of calculation of dearness allowance shall mean the pay drawn in the revised pay band, including the grade pay and NPA, where admissible, but shall not include any other types of pay. In the case of employees who do not opt for a revised structure as per the West Bengal Services Revision of Pay Allowance Rules 2009, the pay shall mean basic pay in the scales of pay as per the West Bengal Revision of Pay Allowances Rules 1993, admissible in paragraph 4 of this memorandum, shall be rounded off to the nearest rupee in each case. So this is a series of memorandums. And may I take you to page 170? 170.
Yes.
So the earlier one which we saw was 23rd February 2009. Now please see what happens on 9th December 2009. Grant of dearness allowance to the state government employees and further ad hoc increase. Your Lordship has that?
Yes.
The governor is pleased to decide that the whole-time state government employees drawing basic pay up to so-and-so shall draw dearness allowance at the rate of 22% with effect from December 1, 2009. So the earlier figure, which you will see last line on page 168, 16%. Your Lordship has last line on page 120,
Yes.
168, 16%.
Yes.
Now, that was in February,
Yes.
with effect from April 2009, has now gone upwards to 22% at page 170. Likewise, since we are on this, please go to page 172. Just mark the third line, 27%. 6th April 2010. And with effect from April 1, 2010.
Yes.
Have your Lordships marked that? 27%?
Yes. Yes. Yes.
Yeah. Then please go to page 174. 35% from 1st December 2010. The date is 23rd November 2010. 35% with effect from December 1, 2010. Your Lordship has that. And then I'll just end with the one at page 176, which is 45%. We'll give you a table, Bharat, so that it will have all
Yes. Yes.
Yeah.
Yes.
Should we hand over a table just now to the court? We've got. Just,
Ready, you give it, not.
yeah, we have it. Yeah, just give it to them. Give it to them. So someone has to follow the rules. The second point is my computation in terms of the rules. Sorry.
I'm not saying that don't argue your case.
No, of course not.
You argue your case, but
Yeah,
just we are trying to gather
yeah.
the
Yeah.
difference between this
Yeah.
index average and AICPI.
Yeah,
Just enlighten us.
yes.
It is not against you. We are
Yes.
just trying to understand the list. You're just trying to understand.
No, I'll endeavor to supply that. I mean, what I have understood. But just have a look at this. Please just take up this sheet, which has just been handed.
Yes, we have.
Right. Now, instead of going from memorandum to memorandum, just please see what has happened. What you will find as far as the government West Bengal is concerned, there is a periodic application of mine. Having regard to the periodic application.
Their grievance is not against this percentage.
No, their grievance at the end of the day is, at the end of the day,
Yet the same percentage would fetch more in terms of rupee
yes,
under AICPI
yes.
and less in terms of index
So
average.
your lordship is
This is
absolutely.
what we have understood.
No, actually, what your lordship.
Date,
So what?
till this time.
Yes. So let me. My understanding is also similar in the sense what the tribunal has required to be done in terms of this revision and revisiting and coming up with principles is to shift the base. I have a
We
base.
have understood
Sorry.
that your case is that if the rules say that it has to be on the basis of index average, tribunal should not have
Correct.
or could not have
Yeah.
shifted the whole calculation
Yeah.
to AICPI base.
Yes.
That is what your argument is.
So this index average of 536, just please have a look at that, page 127. 1982 is 100 rupees. So as and when this particular rule comes into force in 2009 with effect from 2006.
Mr. Diwan.
Yes.
Sorry. Kindly come back to volume 2, page 484, para 33.
Yes. Para 33. Yes. I'm on that.
We appreciate your submission. that the tribunal could not have legislated, could not have issued a mandamus in
To
the.
legislate.
Not difficult. But we are only trying to understand on what basis or how this AICPI came to the knowledge of the tribunal and what was the basis for it to give such a direction. Because you have invited our attention to the statutory provision, which is the rules, the ROPA.
Yes,
And you have invited our attention to 3C Roman 3,
yes,
which speaks of index average.
yeah,
So we are trying to understand what is the difference. My query
correct.
is
That's
this,
the query.
that it speaks of index average.
Yeah.
Where does this AICPI come from?
So,
And what is the difference between the two? Or the other? Please, maybe not. It's almost lunchtime.
yeah,
After lunchtime,
I'll revert to you.
begin.
But if I may just hazard a guess before lunch. So essentially what is the operative direction as far as I am concerned on my understanding is that the central government follows a certain methodology insofar as AICPI is concerned, including periodic revisions as far as the base figure is concerned.
We want to understand what is this concept of AICPI. Where does it come from?
All right, very good.
And what was the basis on which
Yeah.
the tribunal
Yeah.
came to such.
Very good.
That's what.
I'll try and just supply a note. Very good. I'm grateful.
We'll continue after.